Good morning, everyone. I welcome you this morning to a joint seminar or webinar between SCORE Orlando and the Central Florida International Trade Office. One of the things that is very important in any business transaction, and there are some special caveats when you get into international, is the need for contracts. So Chris will be introducing our dear friend, Mary, a local attorney who comes in and helps us on these things. But let me take it just a 30-second elevator speech of SCORE. Most of you, I'm recognizing names as you come in, are probably aware of SCORE. We are an affiliate of the SBA. We're what I refer to as boots on ground. We provide counseling, mentoring, one-on-one consultations with clients or one in a small group of mentors, as well as education, such as this morning's event. We're a true believer in lifelong learning. And if every business person has the education to make the best decisions for their business, the success rate is going to be much, much higher. So we are just tickled to death you're here with us today. And with that, I'm going to turn it over to our co-host, Chris Leggett from the Central Florida Trade Office. Chris.
Thanks so much, Lois, both for helping to organize this as well as that kind introduction. My name is Chris Leggett. I am the program manager of the Central Florida International Trade Office, where we help connect local businesses here in the Central Florida region to the opportunities in the global marketplace. And so if you wonder what we might be able to do for your business, we can provide one-on-one counseling and talk a little bit about why exporting might be a potential way for you to grow sales, or if you need to get more information about how do I import that component that's going to make my product competitive, then we're here to help you with that. We also, like SCORE, put on educational outreach programs, workshops in person and webinars online. And then we also help the two mayors of Orange County and the city of Orlando to host international delegations when they're coming here. And now I have the pleasure of introducing Mary Kogut-Lowell. Mary is a business attorney and the director of the Private Corporate Counsel Program at CPLS-PA. She holds a Bachelor of Arts and a Master of Arts in Romance Languages from the University of Michigan, a Master's in Business Administration and Management from the University of Florida, and a Juris Doctor degree from Wayne State University School of Law in Detroit. As I think you can see behind her there's a few certificates up on the wall. So she is very accomplished, not just in learning, but also in the work that she does. Because during her career, she's worked at a large national law firm in the areas of litigation, corporate law, and international law. She's been in-house counsel for a major airline and has served as litigation director for the Orlando and Tallahassee offices of a statewide law firm, where she handled numerous complex commercial cases. She's also operated her firm representing businesses in various practice areas, including employment law, securities litigation, commercial litigation, appeals, contract drafting, and business transaction. She provides a broad range of transactional legal services focused on helping clients overcome challenges and to achieve their goals. In addition to her career as a lawyer, Ms. Kogut-Lowell has taught at the University of Florida, Florida A&M University College of Law, Barry University School of Law, the University of Michigan, and Valencia College. She's fluent in English and Spanish, proficient in French, and speaks basic Polish. So with that, I'm looking forward to learning about contracts, both domestic and international today. Mary, it's over to you.
Well, thank you, Chris, for that very kind introduction, and thanks to you and to Lois for inviting me here today. I'm delighted to be here to talk about a subject that I love, which is contracts. And as Lois noted, contracts are super important for businesses, as I'm sure most of you know as business people. And so today we're going to be talking about legal considerations when drafting or enforcing contracts for your business. And along the way, we will indeed touch upon some issues that may come up in international transactions. So let's go ahead and get started. Again, my name is Mary Kogut-Lowell. I'm a business attorney and I'm the director of the private corporate counsel program at CPLS PA, which is a law firm in downtown Orlando. And just a brief mention of what we do in the private corporate counsel program. Basically, we provide legal counsel and more to businesses at every stage of the business life cycle. And I like to say it's kind of like having your own in-house counsel and more. So we have a program where we can provide ongoing services. So definitely, if you decide this is something you might like to look into, please visit us at privatecorporatecounsel.com, or you can call us at the number on the slide, 877-647-8778. And then, of course, you know, I'm a lawyer, so we have to have a disclaimer. It's just kind of how we work. This training is for informational and educational purposes only, and we're not providing legal services or legal advice. And so with that, let's get started. This is our agenda for today. First, we're going to talk about what is a contract. We're going to talk about the essential terms of a contract. And then we'll talk about some important drafting considerations. So then we'll talk about enforcement and termination. So enforcement, let's say there's a problem with the contract, the other party's not performing. How do we enforce? What about termination? Say you've got a contract and you want to terminate it. What do you do? And then finally, we'll talk about some common business contracts, because there are several contracts, and we're not going to cover all of them today, but there are certainly certain contracts that many businesses encounter. And so we're going to talk about particular issues that may arise in the context of those common business contracts. So let's get started. What is a contract and why are contracts important? I took a look at a couple of different definitions. The first one you see on the screen is from something called the Restatement of Contracts. That's a treatise that it's not law, but it's often relied upon by judges and lawyers and it's cited in legal opinions. And so they have a definition here on the screen. I didn't find this one to be particularly clear, but since the restatement is important, I included it. It's a contract is a promise or a set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. And that's absolutely true. That is an accurate statement. But I found this other statement in a Florida Bar consumer pamphlet, which is on the Florida Bar website. And I think this is a little clearer. A contract is an agreement between people or legal entities in which one party agrees to perform a service or provide goods in exchange for the payment of money or other goods or services. So I like that, because to have a contract, you have to have an exchange of promises, but there has to be an exchange there has to be what we call consideration, exchange of value. And that's what makes a contract different from a gift. So, and before we get into the meat of this, one more thing I wanted to mention, although I'm not going to spend a lot of time on this, but I think it's something I wanted you to keep in mind. This is what you see on the screen is a Florida jury instruction, and this is what the judges in Florida will instruct juries in a breach of contract case if there's a dispute as to whether a contract existed. And so under this jury instruction, to prove that a contract was created, the claimant has to prove that the essential contract terms were clear enough that the parties understand. The parties agreed to give each other something of value. That's the consideration I mentioned previously. And the parties agreed to the essential terms of the contract. And I just highlighted one thing that I wanted to focus on. So when you examine whether the parties agreed to the terms, ask yourself if, under the circumstances, a reasonable person would conclude from the words and conduct that there was an agreement. So if there's an agreement, there's a question as to whether there's a contract, there's a reasonable person standard that applies. And so we're going to talk a little bit more about that later when we get into contract interpretation. So again, why are contracts important? Well, as we know, miscommunications happen and sometimes people break promises. And if you're wondering, the difference between verbal or written contracts, well, in most cases, you can have a verbal contract and it will be enforceable. But some contracts have to be in writing, such as contracts for the transfer of, real estate. But you can have verbal contracts. But as a sound business practice, all contracts should be in writing and should clearly state what's expected from all parties. And we have just found, and you may have seen this in your own experience, I'm sure, written contracts, if properly drafted, will reduce or eliminate miscommunications. And also, a written contract will facilitate enforcement. If you end up having a dispute and there's a breach of contract, a written contract will make that agreement easier to enforce. We could have a buyer and a seller, and let's say the buyer, the seller agrees to sell something we'll call widgets. I'm going to sell you some blue widgets. That's the agreement, and ships the blue widgets. But then the buyer comes back and said, no, I wanted green widgets. Well, if there's a written contract that says that they're blue, it's a lot easier to show what the terms of the contract are. So I do want to mention, as a sound business practice, we definitely recommend having most contracts, certainly something that's important to your business, should be in writing. And when a dispute arises, the starting point is always the contract. So if there's going to be, if there's a dispute as to whether green or blue widgets were required, pull out that written contract. And in many situations, that's enough to resolve the dispute. But even if it's not enough, the contract will be the starting point. So the bottom line is, always read and understand your contracts. Always, always, always. And if there's something that you don't understand, certainly that's the time to consult with, with legal counsel, because obviously you can anticipate problems if you enter into a contract and you don't understand all the terms. And speaking of terms, what are the common contract terms? As business owners, I'm sure you've seen plenty of contracts in your life. So here's typically what you're going to see: the legal names of the parties. And I wanted to mention this because make sure the correct legal name of your, if you have a business entity, make sure the contract is reflects the correct legal name of your business entity. Contracts will say the effective date. You've probably seen the first paragraph of a contract will say, Party A and Party B enter into this contract effective on January 1st, 2023. That's the effective date. So that's an important contract term that we also see. We will often see a preamble that says the purpose and the scope, whereas Party A does this and whereas Party B does this, and they want to join together to accomplish this. Typically, we'll see in the preamble the purpose and scope. And in many contracts, we'll see definitions. We're going to spend some time talking about definitions today, but it's really important that terms be understood and that anything that not be clear be defined in your contract. You want your contract to clearly list all the responsibilities of the parties, the term. So when will the contract end? Termination is another provision we frequently see, and that is if you want to terminate the contract, how do I do so? You need to look and see if that's in your contract, and if you want to terminate it, those are the steps you follow. And then there's something that you may see referred to as boilerplate. That's standardized text. Oops, I skipped a little bit ahead here. Standardized text. Boy, this definitely shows that you have to be careful here. Standardized text that may be used repeatedly without major changes. And I'm going to talk about more because boilerplate is, those terms are so important. I'll talk more about them in a minute. And then, of course, the closing and the signatures. You want to make sure the signature block correctly, reflects the name of your entity. And then a contract may have schedules and exhibits. So you should be making sure that you understand and that everything in those terms are accurate and complete. Now, again, boilerplate, that's that standardized text that may be used repeatedly in different contracts without major changes. But these standardized terms, we see at issue a lot. So especially when things go wrong. So example, governing law. What law will apply? That's really important. It may not be that crucial if you have a transaction with another party in Florida, but what if you have a transaction with a party in another state or in another country? What law is going to apply? That's really important. And venue. Typically, contracts will state where any litigation must take place. So this is a huge consideration, especially when you're doing business with parties in another state or country. Alternate dispute resolution. Many contracts will say whether if there's a dispute, can you go directly to court and sue the other party, or do you need to mediate and arbitrate? And then most contracts will have some provisions about notices, how, where, and when they're sent. So if party A needs to give notice to party B, does it have to be in writing? How is it sent? Can it be sent by email? Those are all really important things, because if you need to send a notice, you want to do it in compliance with your contract. And then we also see provisions about assignments. That is, can party A or party B assign the contract to another party? So those are things we often see in boilerplate. And definitely governing law, venue, and alternate dispute resolutions are super important. So we're going to talk a little bit more about them ahead. So here are some important drafting considerations. First of all, be clear and concise. Clarity and concision, extremely important. Say what you need to say, and that's it. Avoid ambiguities. All forms of communication are subject to misunderstanding. I have a couple of examples here. The first example, the price of each widget shall be 10 United States dollars. To me, that's pretty darn clear. I know that's the price. It's 10 US dollars. Let's look at another. So that's clear and concise. Let's look at another company, another example. Company A located in Florida asked company B located in France to send a price quotation. So company A sends the quotation, detailed list of price per item, and it also includes the following: all contracts concluded under current price list. And let's say a little bit of time goes by, 45 days later, company A accepts the offer 45 days after receiving it. Now, here's the question. May company A insist on payment to a revised price list in effect when the offer was accepted? So if you look at the contract and it says all contracts concluded under current price list, well, what exactly does that mean, concluded? That's not a term I would typically use in a contract, but let's say that happened to be in the contract. It's not really clear what that means. And so that's the kind of thing I'm talking about here. Avoid ambiguities, especially on key terms like price. It could have been worded in a way where it was clear that these prices, could be replaced by new prices, but that's not that. In this particular case, they didn't do that. So avoid ambiguities. And I don't say never, I would never say never have any ambiguities, because sometimes language is deliberately left ambiguous. For example, the seller shall use reasonable efforts to do X, Y, Z. Suppose I'm the seller and I'm not really, I don't want to be pinned down to something. In this limited circumstance, I may want some language to be ambiguous, a little bit ambiguous, because it helps me as the seller. But generally speaking, avoid ambiguities, because they do lead to problems. And here's another Florida jury instruction. And this is, again, an instruction that Florida judges give to the jury in a breach of contract case. You should assume that the parties intend the disputed terms to have their plain and ordinary meaning, unless you decide that the parties intended a disputed term to have another meaning. So if I have a contract that calls for the sale of blue widgets, not green widgets, it's extremely clear. The plain and ordinary meaning of blue is blue. And there's, there's really, if I have a written contract that says blue, there's really nothing to argue about. So generally speaking, words need to have their plain and ordinary meaning. But what does it mean in that the example from the previous slide, if a contract will be concluded under, not as clear. Even if you give the plain and ordinary meaning of the word conclude, it's, in this context, it's not clear. But so just understand that when interpreting contracts, courts will generally use the plain and ordinary meaning of words. Also be aware that when there are technical special words in Florida, and again, I'm using Florida as an example, but this is common. Disputed terms should be giving the meaning used by people in a trade, business, or technical field, unless the parties agree that the disputed term should have another meaning. So let's say that I have a contract for architectural services, or I have a contract, a building contract. The meaning will be a meaning of a particular word may not be obvious to me, who I'm not an architect, but it could be obvious to architects. And in that case, you would give the meaning, the contract would be enforced according to the meaning in that particular trade. Nevertheless, I think it is definitely a good business practice to define words in the contract if the meaning may not be clear to a reasonable person. And so, for example, architectural terms, they may be pretty clear to architects, but still, it wouldn't be a bad idea. I mean, I would encourage that, they define terms that may not be understood by most people. And here's an example of how things could not be clear. This contract may be terminated by either party upon 3 months written notice to the other party. Okay, 3 months. Does that mean 90 days? Does that mean 3 calendar months? That's why I'm saying, it's really important to define the term that is used in every contract. And also, you've probably seen this in contracts. This is pretty standard. Once a word or phrase is defined, it will customarily begin with a capital letter. So it's common to see in the first paragraph of a contract, John Smith and Jane Smith as sellers, and then they'll be defined as sellers. There'll be a term that's put in parentheses. And then every time the word sellers with a capital S is made in that contract thereafter, we know it's referring to John and Jane Smith. Or XYZ LLC, a Florida limited liability company. Instead of saying every time in the contract, XYZ LLC, a Florida limited liability company, we can say XYZ. So definitions are incredibly important in contracts. And the only time no definition is needed is if the meaning is clear for all parties. So if we talk about something like days, well, we all know what a day is. We know what a liter is. We know what a kilometer is. If we refer to Paris, France, we know what that is. So if the meaning is clear, you don't need a definition, but it's a good business practice in your contracts to make sure that terms are defined so that they're clear to everybody. Now, English is the lingua franca of international commercial agreements. And by lingua franca, I mean the common language. It's used pretty much all over the world in commercial agreements. Nevertheless, you may come across some usage variations. So when I say read and understand your contracts, don't assume that, let's say you've got someone sending you a contract from another country. There may be slight usage variations that you should be aware of. For example, numbering. Buyer shall pay seller this number of US dollars per widget. Now, 1,000 or 1.000. Well, as many of you are aware, there is a different convention in many countries in Europe, not in the UK, but in Europe, a comma is used as a decimal separator. So we're used to using a period as a decimal separator in the US. So I asked the question, which would you prefer to pay? Do you want to pay 1.000 US dollars? Do you want to pay, you're the buyer, so you want to know how much you're going to pay per widget. So just be aware of things like this. There can be usage or usage variations in different areas of the world. And here's another one. When look at dates. Seller shall deliver the goods to buyer on 4/11/2023, or seller shall deliver the goods to buyer on 11/4/2023. Again, in some countries, the custom is to put the month first. That's what we customarily do here in the USA. But in some countries, they put the day of the month and then followed by the month. So just be aware of usage variation. So English is commonly used in contracts all over the world, but you still may encounter some local differences. And also remember how I mentioned previously that trade terms are used as they are customarily used in that trade. Well, internationally, there can be some variation in trade terms as well. And here's an example: free on board, or FOB. Free on board is a term you don't have to use, but you may see it from time to time in commercial contracts. And it talks about basically the risk. When does which party is responsible at what point? So if the seller is selling some goods and shipping them to the buyer, who's responsible for if the goods are lost while en route? That's something that's usually that's something that is usually covered in contracts, and they may not use the term free on board, but just be aware that there's a difference depending on whose rules you're following. There's something called the Incoterms. Those are international trade terms published by the International Chamber of Commerce. And free FOB means one thing under those terms, and FOB means slightly something else under the Uniform Commercial Code that's in effect in the United States, including in Florida. So, just be aware. This is something to be thinking about when you're engaged in international transaction. And also beware of translation problems. I said English is the lingua franca of commercial contracts, but sometimes the parties may think it's useful to have a translation of the contract. I've encountered that in my own practice. I know I helped a client recently with something called a work for hire agreement, which actually I'm going to talk about a little bit later. And that has to do with who owns the copyright when you have an independent contractor or an employee. If you have in this case, it was an independent contractor in another country that was writing something. And so we had a work for hire agreement that would mean that basically the Florida company wanted to own the copyright in what this independent contractor was drafting. And they asked me if we could have the contract in English and Spanish, which I could do. However, I'm very, very cautious. I'm very cautious because I don't care how good you are in two languages. There can be sometimes variations in the translations. So is your company entering into a contract in two or more languages? I always recommend adding a language priority clause. And I gave you a couple examples here. In the event of any discrepancy between the English and the Spanish versions, the English version shall have priority. So if there's some slight nuanced difference in the translation, now we know it's the English version that will take priority. Or another way to say it, this agreement shall be executed in French and English, and the English version shall prevail in case of conflict. And here's another example I came across, which I'm not as fond of, but let's say both parties, neither party, the parties are, there are two parties to a contract, and they both want their own language to be the priority language. Here's an example. This agreement has both an English version and a Chinese version. Both versions are authentic. Where comparison discloses a difference in meaning, the meaning that best reconciles the texts shall be adopted. I'm not a fan of this because I think it's a lot easier if you just say English or Spanish or English or Chinese, but something to consider. So I just wanted to throw that out as something to consider. Translations are very, very tricky. And generally speaking are not recommended because there can be differences in translation. Nevertheless, if the parties want a translation, we can have a translation, but definitely consider adding a language priority clause. Now let's talk about enforcement and termination of contracts. And again, enforcement refers to what happens if there's a dispute. There's a disagreement between the buyer and seller. Many contracts set forth the remedies for violation. It was, as we mentioned earlier, the first place to start is usually your contract. And most breach of contract, if there's going to end up being a dispute that's not resolved, in most cases, a business disagreement can be resolved in court through a breach of contract claim. As we all know, though, litigation can be very lengthy and expensive. So for that reason, to have possibly, sometimes litigation can't be avoided, and it's a very useful tool. But if you can add a dispute, an alternate dispute provision where that talks about mediation or arbitration, and I'll talk a little bit more about the differences between the two, that might be useful. Choice of law, this you should always have. You don't want to, if you're going to have a dispute, you want to know whose rules apply. You want to know the rules of the game. Is it going to be Florida law? Is it going to be California law, or the law of a different country? You should have you should have choice of law provision and where any disputes will be taking place. If you're entering into a contract with a business in California, and they insist upon a venue provision that says any litigation will be decided in the California courts, and they won't budge from that. At that point, it's up to you as a business owner. Make that business decision. Are you willing to litigate in California? If the contract, in the event of a dispute, if the contract is that important and you think you're willing to take that, then fine. But the important thing is you have to, read and understand. But venue is really, really important. So make sure you have provisions about choice of law and venue. And then also, many times in connection with enforcement, contracts will have a provision stating that attorney's fees will be awarded to the prevailing party, and they may also have a liquidated provision. So I will talk a little bit more about each of those. And I wanted to mention the difference between mediation. And in mediation, it's a process where you have a neutral third person called a mediator who acts to encourage and facilitate the dispute. The objective is to help the parties find a mutually acceptable and voluntary agreement. Decision-making authority rests with the parties. So I'm a huge fan of mediation. And it is because you have a neutral third party comes in who will help the parties find common ground. But what I really like about mediation is that decision-making authority rests with the party. So if you can't come up with a settlement agreement that is acceptable to everybody, then that's fine. That's your decision. And I like the parties being able to keep that decision-making authority. Arbitration can be useful, but it's a little bit different. Arbitration is a process where you have a neutral person or a panel. Many times you're going to have a panel, not just one person, who's going to consider the facts and render a decision. And arbitration can be binding or non-binding, but many times in many contracts, you see binding arbitration. So in binding arbitration, the parties agree to be bound by the decision of either a single arbitrator or a panel of arbitrator. And then, and they don't have the right to dispute that decision. Now, a couple of things to know about arbitration. It's, I think, as good as the arbitrators are. So if you don't have good arbitrators, you know, you may not be happy with the decision, but you're going to be stuck with it. And also, arbitration can be expensive. I know it is an alternate dispute resolution procedure, but if you have a panel of arbitrators, the contracts are going to say who's going to pay for them. So it could end up being expensive. Whereas I might, instead of taking to a panel of arbitrators, I might rather be in a court because I don't have to pay for the judge, you know. So arbitration can be really, really expensive. So for that particular reason, I personally prefer mediation over arbitration, although sometimes arbitration can be a good alternative. And also arbitration clauses, you'll find them in a lot of contracts. And this is something that, you know, is included in things like, you know, maybe if you're buying a car, there may check to see if there's an arbitration clause. You may be giving up your right to sue the seller in the event of a dispute. And instead you might be before a panel of arbitrators. And so it's just something to be aware of. But alternate dispute resolution, it's a good idea. If you can mediate a dispute rather than go to court, it's often a great, great idea. And I can't emphasize again how important choice of law and venue is. This is something that's pretty much globally the court, you know, I don't want to say every court everywhere, but it's pretty much accepted that the courts will respect the choice of the parties as to choice of law and venue. Now, attorney's fees to the prevailing party, that provides an incentive to comply with the contract. So I might have a contract that says, you know, that if the case goes to litigation and we have a trial, if I'm the loser, I have to pay the other party's attorney's fees. Well, we all know that could be pretty darn expensive. So that provides an incentive to comply with the contract. Liquidated damages sometimes are good, may or may not be good, but in a liquidated damages provision means that the parties agree ahead of time if there's a breach, what the penalty will be. And that too provides an incentive to comply with the contract. So, and it's in a liquidated damages provision may be very, very useful as long as it's reasonable. Now let's talk about termination of contracts again. Now, the important thing is, again, start with your contract. If the contract has a particular procedure you have to follow, let's say you want to terminate your contract, I got to follow this. You know, if it says I have to give 30 days written notice, then that's what I've got to do to legally terminate that contract. Or if the contract says I can terminate, but I have to pay an early termination fee, look at, and so understand what the contract says. I mentioned here a couple of defenses to enforcement of a contract that you should be aware of. One is impossibility of performance and one is frustration of purpose. So let's say let's say it's impossible. I feel it's impossible for me to continue under the contract. So there may be a breach of contract claim against me. My defense may be it was impossible the contract was impossible to fulfill due to the acts of the other party or an act of nature. That's a circumstance where you may be released from a contract. Again, this is often is not easy to prove, but you should be aware of it. And also there's something called frustration of purpose. If an unforeseen event undermines your purpose of entering into the contract so that the performance is radically different from the performance that was contemplated by both parties, that then the purpose of the contract may be frustrated. That's another possible defense. Not necessarily easy, not necessarily a slam dunk, but it could be used. One good idea, you can also, if you have a contract and you don't like the termination provision, you could try negotiating. The other party may or may not agree, and always with a termination, proceed with caution. If the other party disagrees, the dispute may lead to litigation. But if you terminate in accordance with the terms of the contract, that's your best bet. Okay, so next we will talk about a few common business contracts and some common issues that may arise. First, let's talk about non-disclosure agreements, or sometimes called NDAs. You've heard that probably, sometimes called confidentiality agreement. This is a contract between a person or entity that has confidential information and a person or entity to whom that confidential information would be disclosed. So if in your business you have some confidential information that you want to protect, you may want to enter into a non-disclosure agreement. So what is confidential information? It's really important that that be clearly and accurately defined in the NDA or confidentiality agreement, but generally that it's sensitive information that should reasonably be expected to be maintained in a private manner, such as client information, information about your patents, your other intellectual property. It does not include information that's common knowledge or information that predated the agreement. Now, when do I need an NDA? Whenever you have confidential information or business secrets that you need to protect. They may be used internally with employees to prevent them from disclosing your information to third parties, regardless of whether they're still employed by you. It all depends on the terms of that agreement. And they can also be used with third parties then. Let's say you're going into a business deal and, as part of negotiations, you may have to disclose some business information that's rather sensitive. You could enter into a non-disclosure agreement, which would require that other party not to disclose that information, regardless of whether you actually enter into an agreement. So that, again, is a non-disclosure agreement. And they're particularly useful with trade secrets. And trade secrets are a kind of intellectual property. We're not going to go into intellectual property, but generally intellectual property is referring to trademarks, copyrights, patents, and trade secrets. And in general, any confidential business information that provides an enterprise a competitive edge and is unknown to others may be protected as a trade secret. Let me give you a couple of examples. KFC's secret recipe, or the formula for Coca-Cola. These are trade secrets. Unlike trademarks or unlike patents, there's no way to register trade secrets, but they are protected both under federal and state law. So again, if we think of KFC's secret blend, that's confidential information that provides KFC a competitive edge and is unknown to others. Although I know over the years there have been various speculations that has been disclosed, but KFC has taken steps to protect that information. So that's what we refer to as a trade secret. Having a non-disclosure agreement is very useful, because in this context, I mentioned you can't register trade secrets, but to protect a trade secret, the owner must make reasonable efforts to preserve the secrecy. So if you, let's say, have a non-disclosure agreement, that helps show, if there's going to be litigation, that you made reasonable efforts to preserve the secrecy. So you can enter non-disclosure agreements. You should mark trade secrets as secret or confidential to show that you're making an effort to preserve secrecy, because there is an obligation, if you have a trade secret, to make reasonable efforts to keep it secret. And that protection for a trade secret lasts only until the information is publicly available or the owner no longer has a business advantage from the secrecy. So, so once again, if the formula for Coca-Cola, the official formula, becomes public knowledge and it's released and everybody knows that it's no longer a trade secret. So that it has to be a secret that the company gets a competitive advantage or business advantage from. Non-disclosures agreements are really useful in this particular context. And, I mentioned, trade secrets. Employees and independent contractors may create intellectual property in the course of the employment. And again, this is something I see kind of frequently, and this may happen in your line of work. Do your employees or independent contractors create intellectual property? I mean, do they create something that could be copyrighted? That's the original expression of an idea in a fixed medium. So are they writing something that could be copyrighted? You want to make sure, and if you want to make sure that intellectual property will be owned by your business rather than, let's say, the writer who created copyrightable material, you might want to have something called a work for hire agreement. So just something I've seen, I mentioned earlier, I did that with a client recently, a client who hired some independent contractors to draft something that this client is using in her business. Well, she had a work for hire agreement where the independent contractors agreed that what they were writing would be owned by the business and not by them personally. This issue may never come up in your business, but it's a good thing to think about in case you do have someone who wants to claim a copyright in something. So what do we do under such circumstances? Well, you should have a written agreement that states that any copyrightable work product created by the employee or independent contractor that satisfies the definition of a work for hire under the Federal Copyright Act will be considered a work made for hire, because the federal copyright specifically says you can have something, I can hire somebody to write something for me, and if I have an appropriate agreement, I own the copyright, not the person who actually wrote it. And then in addition to saying it's a work for hire, the agreement should assign to the company all work product that doesn't qualify as a work made for hire, including inventions or discoveries. So something to keep in mind. Again, I'm talking about common business contracts, so this may or may not apply in your work, but I see these from time to time, and so I wanted to mention them today. And since I mentioned independent contractor agreements, let's talk about what is an independent contractor. And if you have an independent contractor agreement, what happens? Well, why is that important? You really need to properly characterize workers. Because, if you have an independent contractor, you're not going to be withholding taxes like you would for an employee. So some businesses may like to use independent contractors because it sort of streamlines what they need to do. But it's really important that you characterize your workers carefully. So, and it's important to understand that if you call someone an independent contractor and even have an independent contractor written agreement, that's not necessarily binding on the Internal Revenue Service. The IRS could still look at that person and say, you're calling an independent contractor, but it's really a worker. So guess what? You got to, you're going to have to pay back taxes on that person. And what's the test? It's mainly based on control. The more control that a business has on a worker, the more likely the IRS is going to consider that worker an employee rather an independent contractor. And there's different kinds of control that the IRS would look at. Does the business have a right to direct and control what work is accomplished? Where is it accomplished? Do you have a right to require that person work in your office as opposed to at a location of his or her choice? When does this independent contractor, so-called, have to work regular hours, from 9 to 5 every day? So the more control you have, the more likely the IRS would deem that person to be an independent contractor. And, so the IRS will look at evidence such as contracts, but just be aware that, having an independent contractor agreement is very, very useful. but it's not necessarily going to be controlling if the IRS disagrees. Nevertheless, if you definitely have an independent contractor, it's a good idea to have that independent contractor agreement in place. So I mentioned there could be penalties if you misclassify workers, IRS penalties, there can be fines, percentage penalty on employee wages, and you might have to pay back taxes. So it's just be aware that there are penalties. So it's important to properly characterize your workers. And if you have an independent contractor, good, have a properly drafted independent contractor agreement. Now, one final kind of contract, commercial contract that most businesses will come into contact with will be leases. And a lease is a contract in which the owner of property allows the use of the property for a specified period of time for periodic payments. So the period of time is the term, periodic payments will be the rent, and will specify other terms and conditions. So you can have a real property lease, you might have a commercial lease on where your office is located, or you could have leases of property. You might have a lease for, let's say, a copy machine. So the bottom line, once again, read and understand your lease. Consider the term of the lease. Make sure you understand how long the lease will last. Who pays for maintenance and how much? If you have an office lease and there's going to be a build out, do you have a right to build out? Who's going to pay? Who's going to pay for the build out? Can you renew the lease? If so, for how long? Does the landlord have a right to terminate? And let's say you as the lessee, do you have the right to assign to a different business? Or what do you need to do if you want to leave and you want to assign? Can you do that? This is a big one. Is a personal guarantee required? Remember, I mentioned always in your contracts, don't make sure it has the proper legal name of the party. So as a business owner, you're going to want to have, and you formed an entity, you're going to want to have the lease in the name of your entity. Nevertheless, some commercial landlords will require a personal guarantee. So it's important that you understand that you personally are guaranteeing those lease payments. So it's not just your company, it's you personally, you're guaranteeing it. And what happens, this is a biggie, what happens in the event of unforeseen circumstances, such as a pandemic? Well, we all have gone through COVID, and we saw what happened in COVID. And I know I had a number of clients come to me saying, I have to close down the business. There's been a government shutdown, we can't pay the rent anymore. What are we going to do? So what happens in the event of unforeseen circumstances, such as a pandemic? That's a really important provision for you to take a look at in your lease. And the answer may depend on whether the lease includes something called a force majeure clause. That means a larger force clause. This may free both parties from the lease or other contract when an extraordinary event beyond the control of the parties prevents one or both parties from fulfilling obligations under the contract. Now, I've seen different force majeure provisions. Typically, I have seen them in the event of, parties are, can be excused in the event of a war, strike, riot, crime, act of God. I really didn't see many saying epidemic prior to COVID. Although I think that's something definitely to think about. And also, so let's say there is, let's say you have a provision that releases you in the event of an epidemic. Well, be aware that most force majeure clauses don't excuse your non-performance entirely, but only while that intervening force is happening. So it's generally intended to include occurrences beyond the reasonable control of a party. I mention this just because I saw this issue come up for certain businesses, not all, but some businesses during COVID. So in future leases, considering including language specifying the parties' rights if you're unable to form due to COVID-19, pandemics, government shutdowns, etc. So that's the presentation. I'm going to look in a minute and see what the questions are, but I did want to mention To learn more about the CPLS PA Private Corporate Counsel Program and how we can help you and your business on your journey to success, please call 877-647-7887 or visit privatecorporatecounsel.com. Also, feel free to reach out to me directly. My email is on the screen here. It's mkogut@cplspa.com. And we have a couple minutes left, so maybe let's see if I can see a couple of questions here. The first one, attorney's fees to the prevailing party. Should you say reasonable fees? Yes. I think reasonable fee. Now, of course, the word reasonable is subject to interpretation. Yes, I think it's a good idea to say reasonable fees because, it's not reasonable, let's say, to be paying an attorney. Well, some attorneys may disagree with me, but a couple $1,000s per hour. Now, reasonable attorney's fees, it should say reasonable attorney's fees. I think that's a really good, and also you can have, if you agree to arbitration, typically it will say who's going to pay for the arbitrators. That will typically be in the provision. And yes, that is a good idea. What if the employer does not pay for the work as hire agreed? Well, I think that's a really good question. So you have a work for hire agreement, but then let's say the independent contractor is not paid. Does the copyright remain with the contractor? I'd say definitely the contractor has a breach of contract claim. And, it's not clear what would happen. But I think that in a breach of contract case, I think the contractor could argue, I haven't been paid for it, so the work for hire agreement is void. That's something that could be litigated in court. Copyright IP. If an employee writes a song for business, but writes it after hours. Okay. It really depends. No, because really typically what you're going to have, if you're doing it, are you doing it on your own time? Typically that work for hire agreement, is it specifically what you agreed to do for the business, or are you doing it for yourself? So what's really important is to have a contract that specifies what songs will be covered and what won't. So it should be specified in the contract. And do we recommend a small business have employment contracts, or will an office letter suffice? That's a really good idea. Good question. Typically in Florida, it depends on the employee. I more often see employment contracts with CEOs, people very high up. I less frequently see them with, let's say, employees in the, let's say farther down on the chain of command. As the employer, remember, Florida is an employment at will state, which means either party can terminate the contract at will. As long as you're not doing it for a prohibited reason, like this, racial discrimination, sex discrimination, and so forth. So most employers don't want to have an employment contract unless there's a good reason to have it, like with the CEO, etc. And let's see, I think those are all the questions. So thank you all. I really am very happy to meet you all today. And thank you again, Chris and Lois.
Well, thank you, Mary, for taking the time today to talk about contracts. This really is the foundation of a good business relationship, is having a strong contract, as well as helping, if you're in sales, having that contract is going to help your other team members to understand what it is that you've agreed to on their behalf, and will help them with performance of the contract as well. And thank you, everyone, for joining us today. This has been hopefully as great a learning experience for you as it has been for me. The next part we'll be having on either the 12th or 24th of January. We're just finalizing dates to talk about how to market your idea, your business. Lois, who you heard from earlier, is going to be one of the speakers on that, and you're going to learn a lot that will help you take your product from concept to consumer. So again, thanks very much today, everybody.